My name is Christine Lai, and I'm the founder of Special Education Legal Fund. Let me start with a question. How many of you have ever left a school meeting thinking, I don't agree with what they decided, but I'm not sure what just happened or what I can do next? If that's ever been you, I want you to know something important. You are not powerless, and there is a document designed specifically to protect you. It's the most important document you've never heard of. It's called prior written notice. Most parents have never heard of it. Some educators barely mention it. But prior written notice, often called PWN, is one of the strongest legal rights that parents have in special education. And today, I'm going to show you why it matters. Prior written notice applies to students who are suspected of needing or already receiving special education services. It does not apply to 504 plans. It is a federal legal right tied to a student's IEP. And here's what it does. Anytime a school proposes a change to your child's educational plan or refuses a request that you made, they must explain that decision in writing, not in a phone call, not verbally at a meeting, not buried in educational jargon, in writing. Why does that matter? Because writing slows things down. Writing forces clarity, and writing creates accountability. Prior written notice isn't just a summary. It is a full explanation. It must include what the school's proposing or refusing, why the school made that decision, what evaluations or assessments the school relied upon to make that decision, what other options were considered, and why they weren't proposed, and finally, where parents can get help understanding their rights. This isn't bureaucracy for bureaucracy's sake. This is about informed consent. It's about giving parents the information they need to meaningfully participate in decisions about their child's education. Here's the truth. Disagreements are going to happen in special education between the school and families. Disagreements are not a failure. They're part of the advocacy process. And prior written notice protects families because it helps parents understand why the school disagrees, shows the information that the school relied upon to make those decisions, and discourages biased or poorly supported decisions. Prior written notice also protects families because it can become evidence if the dispute escalates later to mediation or due process. In other words, prior written notice doesn't create conflict. It documents reality. So when is PWN required? Schools are required to issue prior written notice when they conduct or refuse an evaluation, when they deny a parent request, when a student is found ineligible for services, when there's a change in the student's disability category, when there's a change in placement, or when student services are increased, reduced, or removed. But prior written notice is not required for general screenings, done for all students, state testing, classroom schedule changes, or teacher assignments. Knowing that difference matters because not every change requires prior written notice, but the important ones do. Here's a detail that many parents don't know. You must receive prior written notice before the changes happen, not after. This is so that you have time to review the change, time to ask questions, time to challenge it if necessary. But if you don't respond, changes can be implemented after a set period of time. But if you don't receive prior written notice, you should request it immediately in writing. No prior written notice means that the process wasn't properly followed. Another critical point: schools are required to provide prior written notice in a family's home language. If written translation of prior written notice isn't available, they must provide verbal interpretation. The school must ensure that you as a parent understand prior written notice. This isn't optional. And if you don't understand it, you need to keep asking questions until you do. And here's one last thing that every parent should know. If your request does not appear in prior written notice, you can and should request an amendment immediately. Every proposal, every refusal, every decision needs to be documented in prior written notice. Because if silence is on paper, that can erase real advocacy. Prior written notice might sound like a technical document, but in practice, it represents something much bigger. Prior written notice represents transparency and accountability. And PWN is a pause button in a system that often moves too fast for parents to understand. And most importantly, it reminds parents of something essential. You are not just invited to the table. You are a decision maker in your child's special education process, and the law is on your side.